May it please the court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
Sure.
Thank you.
Mr. Stopa, this issue, this is what, the fifth or sixth or seventh argument that you both had?
I think it's number 7 for me
Number
on this
7?
559-715.
All right.
And, Judge, I was actually going to start with that. It's funny you say that, because in a lot of the prior oral arguments, including a couple with you, I think this is my third with
Yes,
you, the issue has come up of, is this the right case, correct case to write an opinion on? There were preservation issues, and some of the cases turned on factual disputes potentially. To me, this is the perfect fact pattern to write an opinion on. It's de novo review. Everything was preserved. They're not even arguing preservation at all. This isn't a case that turns on the facts at all, because the other side had no notice of assignment of the debt as contemplated by the statute, and they acknowledge that in their own testimony. You purely have the legal issue of whether the statute applies in the mortgage foreclosure context.
One of the issues I think is raised in the briefs is there anything that indicates that this is anything other than a residential foreclosure? Because if it's a consumer debt, I'm assuming it has to be a residence. It can't be commercial property. It can't be rental property.
Sure.
Do we know that for sure?
I think it's clear that it's a residence, but I would also submit, and I talked about this in the brief, to the extent that the record was unclear, it's the plaintiff's burden of proof to prove compliance with a condition precedent, and if the record were silent on that issue, I think it's pretty clear it was a residence. But if the record had been silent on that issue, they didn't meet their burden. I cite the Boltby case out of the 5th DCA that's really clear on that, and the standard jury instruction out of the Florida Supreme Court for a condition precedent puts the burden of proof on plaintiffs. So, to me, that doesn't help.
The loan documents suggest that it's supposed to be a structure that is going to be used as a residence.
Correct.
But I think that's all I could see.
I don't think there was anything beyond that.
Well, I know the test under the federal law is what is the intended purpose of the loan at its inception. So even if let down the road they decided to rent this out, it's still, I think if it's...
Totally agree with that. And to me, the way this case unfolded, it would have been the plaintiff's burden at trial to put on some evidence that this loan was not taken out for personal, family, or household purposes. That's how the FCCPA defines debt, as this was for a personal, family, or household purposes.
So the question is does it apply? So the question before us is, does it apply to an attempt to foreclose on the security for the consumer debt, assuming this meets the definition of a consumer, versus a direct suit on the debt itself?
I would rephrase your question slightly. I think the first question is a mortgage foreclosure suit that is precipitated by a letter demanding money, and that includes a request for deficiency in the complaint, is that an action to collect debt? Because that is the fact pattern that you have before, Your Honors.
That's different. If that's accurate, that's different than what I've seen in some of the 11th Circuit cases.
Right.
We're not just, am I accurate? We're just not trying to foreclose our security interest. We've made a demand for money, and there's a request in the complaint
For money beyond the security.
Right, and I do think there are different permutations of the facts in some of these cases. For instance, in the Burster case of the 11th Circuit, that was only a letter demanding money, a paragraph 22 letter. And there the 11th Circuit said just the letter demanding money is debt collection. Well, here you clearly have the paragraph 22 letter. They introduced it into evidence at trial, right?
Because it's always supposed to be a paragraph 22.
Exactly. Well, on your standard Fannie Mae mortgage,
right.
Sure. So to me, that clearly makes this an action to collect data under the 11th Circuit precedent. And to me, the other cases, the 3rd Circuit, 4th Circuit, 6th Circuit, those are really powerful decisions. For instance, the Glazer decision, 6th Circuit Federal 2013, filing any type of mortgage foreclosure action, even one not seeking a money judgment on the unpaid debt, is debt collection under the Act.
Well, even if it's debt collection, as I read the Florida statute, there's no private cause of action. You agree with that? So
totally.
I'm struggling with the notion, how does that inform our thinking about how I can challenge it as a failure to comply with a condition precedent?
Well, to me, that shows that it has to be a condition precedent, right? Because The question becomes, we all know that you have to give meaning and effect to all provisions of a statute, particularly in the consumer protection context. So where you can't sue as a consumer for a violation of 559.715, the question becomes, how does a court enforce the plain language of the statute requiring the notice be given 30 days before any action to collect debt?
Or the statutory scheme provides for a regulatory enforcement of the provision. I mean, you may think it's inadequate, but it does provide for regulatory enforcement.
I respectfully cannot imagine a decision coming out of this court in the consumer protection context that says that the remedy is, well, go hope that the state attorney files for an injunction. If that's the remedy that you're discussing, that's the only one that they even argue in the statutes. I just can't imagine that.
So, so every mortgagor becomes a private attorney general.
I believe that, and I've cited several cases on this, that the language of the statute, the way that it's worded, consistent with longstanding precedent, operates as a mandatory condition precedent. I cite the U.S. Supreme Court in Hallstrom. I cite a Florida Supreme Court decision. I just did a supplemental authority on that yesterday. I just recently found it. A second district decision and a fourth DCA in-bank decision with no dissents. All of those cases hold that where you have a statute that requires a notice to be given before an action is taken, even where that statute doesn't have the term condition precedent in it, that notice is a mandatory condition precedent as a matter of law. The way I argue this, and I do it all the time, I basically challenge everyone who comes across this to present an opposing case, right? Here we have Ackerman today. If there were an opposing case, you know that they would have it here. There is no case in any context, anywhere, ever, that interprets a statute that requires a notice to be given before an action taken as anything other than a condition precedent.
And it's interesting, Mr. Stopa, because bringing these issues all the time, you have a number of circuit judges who've gone your way. You've got a number who've gone the other way. You've got Middle District of Florida going one way. You've got the Southern District going a different way. So there's a lot of, obviously this is a very hot issue for debate. So take a moment and say, why is this an action to collect the debt?
Because the way that the FCCPA defines an action to collect, defines debt, and the way that the federal cases construe that, and the way that this court in Gann interprets that, it just has to be. For instance, Gann, which follows Reese, explains how, why would an action to collect money be an action to collect debt, but if you're foreclosing a security interest that secures that money, not be an action to collect debt. That would create a loophole in the FCCPA. That wouldn't make sense. That's what the 11th Circuit said in Reese. And this court followed that decision in Gann. Judge Northcott, you were part of that Gann decision in saying, we're not going to do that. We're going to follow those 11th Circuit decisions. Now, the trial court decisions, and there certainly are trial court decisions that have gone against me on this issue, I submit, just as Judge Silberman noted it a couple weeks ago at an oral argument, those decisions really don't have any analysis in them, right? They just kind of have one sentence of, this isn't a condition precedent, like Summerlin, that my opponent cites a supplemental authority. One sentence, this is not a condition precedent. They cite 2 circuit court decisions as authority. That's all they cite. I was counsel in both those cases. Both those decisions predate this court's controlling decision in Gann, and there was no explanation about the cases that I give, like Hallstrom or Neat or Freeney, that have a statute that requires a notice before a suit is filed as anything other than a condition precedent. Trent, out of the Middle District of Florida, to me, that's one trial judge's decision, right? One. Summerlin is one trial judge decision. I have 47 trial judge decisions, and look at the appellate panels, right? The appellate panels, I feel like those all go in my favor. Not just this court's decision in Gann, but you've got the 3rd Circuit, the 4th Circuit, the 6th Circuit, the 10th Circuit, and the 11th Circuit. My opponent can't cite to any appellate panels that go their way on this issue at all. And these appellate panels, unlike the trial court decisions, which typically have the trial court judges that go against me on this, they really don't have any analysis of the 1 or 2 lines. If you read these appellate panels I've cited, these are pages and pages of analysis. For instance, in Glazer, we hold that mortgage foreclosure is debt collection under the Act, and then the decision is pages long explaining why that is with analysis. The 4th Circuit did the same thing in Wilson. These are the decisions that go my way have long analysis. The only appellate...
Is this a strict liability situation? I guess my question is, what's the harm to your client of not having gotten the notice of assignment?
Well, To me, the best way to answer that question, and I'll try to answer it more directly, is that harm is not a part of the analysis. And I cite a Florida Supreme Court decision in my amended reply brief that says if the legislature, for a statutory condition precedent, if the legislature wanted prejudice to be part of the analysis, they would have made prejudice a factor in the statute. Where the legislature doesn't make prejudice a part of the analysis for a statutory condition precedent, courts can't do so. That was the Strescon case out of the Florida Supreme Court.
Is there anything that the notice of assignment would have given you that was not provided by the paragraph 22 letter prior to the institution of foreclosure proceedings?
Who the plaintiff is. The paragraph 22 letter gave no mention of the plaintiff at all, no mention of the entity that was filing the suit at all. No mention whatsoever. And so I submit that your question goes to, well, what is the purpose or what is the intent of the statute, which to me, you don't get to that question as a matter of statutory construction when you have a statute that is clear and unambiguous on its face. It requires a notice to be given before an action is taken. Prejudice is not a factor in the analysis, and neither is equity.
So let me ask you a question, Mr. Trump. Let's just assume we go your way, we agree with you. What's the result? We make a finding that, yes, it should have been a condition precedent. What effect does that have then? This case goes back?
Oh, no, I think it's very clear, Judge, and I think it was implicitly admitted in their briefs that the remedy has to be reverse and remand for an involuntary dismissal without prejudice. That's the result in the paragraph 22 context, like the 4th DCA has held twice. In the Holt decision, for instance, if the paragraph 22 letter isn't given, that's a condition precedent, right? The remedy is reverse and remand for an involuntary dismissal. There's no new trial. That's the same thing you have when a plaintiff doesn't prove standing. There's legions of cases on that. I mean, I feel like I spelled those out very clearly in my initial brief, and then my opponent...
They can refile.
Sure, of course,
They could
right.
refile within the statute.
Right, dismiss without
limitation.
prejudice, right. There's no new trial, they can dismiss without prejudice. So you reverse and remand for an involuntary dismissal without prejudice. I don't think they even argued otherwise. I know they didn't argue otherwise in their answer brief, so I don't think there's any dispute about that. When you don't comply with the condition precedent, it should be dismissed without prejudice. Now, equity is not part of the analysis here either, and my opponent talked about this, and having done this so many times now, I sort of want to talk about that because I kind of have the impression, I almost feel like I've argued this in bank at this point.
Well, it's really not an issue, but it's really not an issue because your argument is it's a legal one. So we
Sure.
can't, and the legal.
Purely a matter of contract and statute.
Exactly,
Thank you.
and nothing to do with equity. And I know a lot of people would say, well, but look at your clients. That's aside. You have to set that aside.
Thank you. Thank you.
You're
Because
a poor one-legged guy who can't see, no, you don't even have to do that, do you?
yeah, to me, it's very clear that equity is not part of the analysis. My opponents argued in their brief that it should be. You can't go down that road. This is a legal issue. Either the notice was given or it's not. You can